All right, everyone. We're still trying to add our third speaker, but I'll get to that while our first two panelists go through their presentations. So, welcome everyone to, I guess, day 4 of North American Carbon World, and for attending this side event on all things Canadian carbon. So, my name is Matt Lithgow. I'm a senior North American environmental markets correspondent at Carbon Pulse. And I'm very pleased to be joined today by 3 of the foremost experts in all things Canadian carbon. We have Jonathan McGivelry, who is a senior associate at Toronto-based law firm Resilient LLP. Michael Berends, who is the managing director of Origination at Toronto-based analysts and consultancy ClearBlue Markets. And we are trying at the moment to bring on our third speaker, who's with us but just not on yet. In Chelsea Bryant, Managing Director of Global Markets and Strategy at Calgary-based offset project developer and consultancy Radicle. So welcome to you all. Thanks for sticking around over this absolute torrent of a carbon pricing and climate policy week to end out April. Without further ado, as I mentioned before, there's a poll in the right-hand side of the event page. Fill that out, and we'll get to that after our panelists go through the presentation. But we're going to be starting off here with a couple of presentations before we get into a moderated discussion and hopefully Q&A at the end, where Jonathan will first take us through some of the recent Supreme Court decision ruling that came out in March that paved the way for the current federal government's carbon pricing landscape to stay intact. And then Mike will round us off with the current landscape of how the federal and provincial systems that are in place now are operating and might interact going forward. We're going to try and get Chelsea on here, and so she'll be able to give a presentation from the Alberta and voluntary market perspective, and then we'll move into there. So Jonathan, the floor is yours.
Thanks so much, Matt, and great to be here with all of you today. As Matt mentioned, I am a senior associate at Resilient LLP, and we were very fortunate to act as intervenor counsel to the International Emissions Trading Association in all 4 of the court cases that happened over the last 3 years or so, starting in Saskatchewan and then moving to Ontario and then moving to Alberta and finally up to the Supreme Court in September of last year. We were quite excited and waiting with bated breath for the decision to finally come down from the Supreme Court, and it came down on March 25th, roughly a month ago. And as Matt mentioned, it really did allow for the federal scheme in Canada to stay intact and settled a long-standing jurisdictional fight between 3 Canadian provinces and the federal government over jurisdiction on carbon pricing. One very clear result of the case and one of its key implications is that both the federal government and the provinces have the jurisdiction to implement carbon pricing in Canada. And furthermore, the federal government has the authority to set minimum national standards for greenhouse gas emission price stringency for the provinces. So I'll dig into the bit. I won't go through every element of it. It's a nearly 400-page decision. It was not a slam dunk. It was a 6-3 decision, 6 judges in favor of upholding the act, 3 judges dissenting. Obviously, majority required. So we had a little bit of a margin, but not a strong margin. And the court ultimately found that the Greenhouse Gas Pollution Pricing Act, that's Canada's federal carbon pricing system, was constitutional under what's known as the Peace, Order and Good Government Clause of Section 91 of the Canadian Constitution. So I'll get into that a little bit, starting with the approach that the majority took in reaching that conclusion. In Canadian constitutional law, there is a 2-stage approach to a division of powers analysis under the Canadian Constitution to uphold the validity or to strike down the validity of a statute. So first, the court works to characterize the nature of the law, and then second, the court works to classify the law. So in this case, the Supreme Court determined that the pith and substance, or the subject matter of the federal law, was, quote, establishing minimum national standards of GHG price stringency to reduce greenhouse gas emissions. And that came from the arguments, actually, of the Attorney General of British Columbia, who really were able to crystallize that subject matter of the statute for the court. The court confirmed that each and all of the title, the preamble, Hansard, the purpose, effect, implications, and the integral means by which the purpose is implemented are all relevant in characterizing the matter. And the Chief Justice actually confirmed that the matter must be construed precisely, which is distinct from narrowly. So that was the first stage of the analysis. And after they navigated that first stage and determined what the subject matter of the act is, they moved on to classify it under the division of powers set out in section 91 and 92 of the Canadian Constitution. And there's a series of steps involved in that analysis. The court confirmed that the national concern test, which is the branch of the peace, order, and good government clause that the court decided to go with, was to analyze a threshold question, and then analyze the singleness, distinctiveness, and indivisibility of the issue, and finally assess the scale of impact. And they went through that analysis and determined that indeed the Federal Greenhouse Gas Pollution Pricing Act is constitutional under what's known as the national concern branch of the peace, order, and good government power of the federal parliament. So it's not as straightforward as you might hope, but we got there. Several parties made arguments that the act might be constitutional under other heads of power in the Canadian Constitution, but the court ultimately didn't go in those directions and stuck with the peace, order, and good government power. Some of the key implications are that we now have some certainty over how federal carbon pricing operates in Canada, and we know that the federal system can continue to operate as a constitutional mechanism. To some extent, it ends the looming uncertainty over Canada's jurisdiction to enact carbon pricing, and provides Canadian businesses with the much needed certainty to move forward with long-term planning. It does so in a manner that could be precedent-setting for other jurisdictions. On carbon market mechanisms in particular, I'll just read one passage from the court, which we think will probably be picked up in other court cases and in arbitration. And that's from paragraph 170 of the decision. The majority strongly endorsed carbon pricing as an essential legislative tool, and it said, quote, "There is broad consensus among international expert bodies that carbon pricing is a critical measure for the reduction of GHG emissions, and that the matter of the federal statute, the GGPPA, is critical to our response to an existential threat to human life in Canada and around the world." So it really crystallizes the statute and its purpose. And we expect that that endorsement of carbon pricing and of market mechanisms more generally will likely get picked up by other courts and in arbitrations going forward. Matt, I'll turn it back to you.
Thank you so much, Jonathan, for really masterful, succinct overview there. Before we get into Mike's presentation, I'll just read off the results of the poll right here so we have a bit of a framing going forward. Out of, I guess, 22 votes here, 8 said that they are familiar with Canadian carbon pricing, 7 are not that familiar, and 6 are very familiar. So at least everyone has, almost everyone, I should say, has some inkling of what's going on, and that kind of splits. And I think it might be actually shifting now more towards the not that familiar, but still a fair amount. So with that in mind, Mike, I'll turn it over to you.
Thanks, Matt. Thanks, Jonathan. It's great to have a lawyer on this session because I always struggle trying to explain what you just did in the Supreme Court. So thanks for that. And now I can get into what it means on the ground with the emitters and all the the certainty/uncertainty. So I'm going to load a few slides. So let me see if this works. And please let me know if you see the main slide when I do this. Matt, do you see the single slide or do you see the fancy slideshow screen?
I'll only see you, Mike.
Really? Oh, one sec. It would help if I press the other button. Yeah, that's a mess. You see a lot of me. How about now? Matt?
We see the main slide.
The main slide, perfect. Okay, sorry about that. Always these new programs each time. Great. So look, thanks for that, Jonathan, and the clear explanation of what's happened with the court case. You know, that court case has led to a lot of, prior to the court case has led to a lot of, I would say, uncertainty in where carbon pricing is or was going in Canada. And that uncertainty has led to this patchwork of carbon pricing that we currently see today in Canada. And this is basically a result of, the different provinces playing their cards on how they're going to accept or not accept the federal system. Some provinces were in ahead of this and made their own plans, had them for a while, considering that British Columbia, for example, in Quebec. Some provinces also had carbon pricing for a long time, such as Alberta, but they didn't necessarily want to have the same pricing levels as the federal government. So they currently have a hybrid system between the emitter program accepted by the feds and the federal carbon tax, is called the fuel charge, that's imposed by the feds in that province. So you see some of these sort of hybrid systems you see here. And then you have Ontario, for example, that did have a cap and trade program, which probably many of you are aware of, but they removed it quite quickly once the new government came into power back in 2018. And they would have had the same program as Quebec, but they currently face the full federal backstop and the fuel charge. So you're seeing that, but that will slowly change. The result is not only was there uncertainty up until now, and there still will be because these changes will still continue. The prices are different, and that's really interesting when you think about the equivalency and the different discussions that were had at the Supreme Court, saying, okay, we're going to deem provincial programs equivalent or not to the federal program. And even though they've done that with a few provinces and they've said, yes, your program is equivalent to ours, you can keep yours in place, there's different prices in these programs. And that's very interesting. You look at Quebec, their price is currently at $23 or so, $23.50. It's been going up recently per ton of CO2. And Ontario, for example, with the federal backstop in place, it's at $40. And that's very interesting and very relevant for what we pay as individuals at the fuel tank, at our natural gas bills, because that is exactly the equivalent cost of carbon that we pay there. So the end result is it is cheaper in Quebec than it is in Ontario. But I should mention something that in Canada, under the federal backstop and the federal fuel charge, we do get a rebate when we fill our taxes in. And in Quebec, you don't get that rebate. So there is some difference there.
Mike, real quick, can you put your slide on slideshow mode, on presentation mode? Some people can't read what's going on. Yeah, top. There you go. Perfect.
Is that better?
Thank you.
Oh, okay, perfect. Sir, yep. So what I was saying there, sorry, is that there is a rebate that's given out to those that are facing the fuel charge, and you don't get that in Quebec. So that can make up for some of the differences in pricing. But at the end of the day, the carbon price is cheaper in Quebec, and the rules allow for that. It's going to be interesting now that we've seen this court case come out and say, okay, the feds have the right to impose carbon pricing. And a lot of questions have come up now saying, why are we paying $40 when, for example, Quebec is paying $23? The reality is that Ontario, if they didn't remove their cap and trade program, would have roughly the same price. They would have the same price as Quebec today if they hadn't done it. So it's not about Quebec being treated in a unique way. It's about the program they decided to keep, which is a cap and trade program. And if others follow suit, they could have a similar carbon price. And we'll see how that goes going forward. All that to say that now that we have clarity on the Supreme Court side of things, on the federal level, we're hearing different provinces come out and say, we may consider changing our program and maybe even consider changing to a cap and trade program. So that's something to watch closely as we go forward. In all of this, actually just prior to the court case back in the fall, Ontario's emitter program called the EPS program was suddenly approved by the feds to start and we just found out recently to start in 2022. So Ontario now will have a third program in roughly 4 years coming soon. This, of course, makes it very difficult for emitters to understand what their forecasts for costs is going to be. And there is possibility that might not be the only program that we'll end up with in Ontario over the next few years. So as much as we have more certainty today when it comes to the Supreme Court case, there's still a lot of uncertainty on what exactly will the programs look like over the next few years as everyone's figuring out what they want to do now that they have this clarity from the federal government and the Supreme Court. So we look at what the Feds has done. There's a lot of announcements being made over the last few weeks. I think the interpretation was after the election win by Biden, Canada want to remain ambitious with what they're doing in regards to carbon pricing. So back in December, Canada only had a carbon price stated up until 2022 of $50. The federal government came out with a new carbon price forecast of going up to 170 by 2030, which is significant. It's a very significant price to be at 2030. If we think about Quebec and what Quebec has as a price today, and what we see as a price forecast for roughly the same time period of 2030, under WCI, it's more under the $100 range or so. So the question is it more reason if the federal government decides that cap and trade can have their own prices that are not following this same price levels, will other provinces join cap and trade? And I think I mentioned on the last talk that we gave is, it could be a very interesting discussion to see if Ontario would ever try to get back into cap and trade, to try to get into cap and trade that's linked to Quebec and of course California, and more importantly, would those two jurisdictions actually accept Ontario coming back after the experience they had with them last time? So this price level that we're seeing here going out to 2030 will be very important to see what that impact will be on decisions on what kind of carbon pricing that you'll see in the different provinces we have in Canada. Ideally, you'll see more linkages and grouping of these programs and not have this messy patchwork of carbon pricing that we see today in Canada. So, we want to say that carbon pricing is more certain, but it's still not there yet. We still have the stroke of pen risk where Ontario, we've seen this. We're going to have in 2022 the third carbon pricing program in 4 years in Ontario. And as a matter of fact, the first payment ever made by emitters under carbon pricing only happened, was it last week or a week and a half ago, even though we've had carbon pricing in Ontario since 2017. And all of this has led to, and I think Chelsea, you'll speak to this, and I'll show one other slide on offsets, is that it's also caused a lot of delays on some of the fundamental aspects of these programs. So for example, the federal program has been in place in a number of jurisdictions since January 1st, 2019. And we still don't have offsets in that program. And I'll show some numbers in the next slide, but it's a problem. They allow for offsets to be used in the program. Actually, 100% of the compliance for the first 3 years can be used via offsets if they're available. They're just not there because the program has not been developed. So all this uncertainty has led to delays, but we do see this picking up, and hopefully this will continue going forward in a positive step and bring more certainty. But it'll be something to watch for as well. And then as well, there's current ongoing negotiations with emitters on what their positions, what their stringency benchmarks look like at the federal level. And the question that the emitters are asking, will it be relevant? Should I be speaking to the federal government? Should I be speaking to the provincial government? Who's going to be the one that's making the decisions for my facility over the next 10 years? And it's still not very clear, because actually each year the federal government, the way the rules work today, have to deem each provincial jurisdiction equivalent. And if they're not deemed equivalent, in theory, that means the federal system comes back into force. So this uncertainty still hangs over the future of carbon pricing in each province. And then to the other point, will there be more cap and trade? Looking at the rules today, cap and trade for the most part, especially on individuals, is cheaper. That's just the way it looks like as we speak. The other big news that came out over the last few weeks was that the other major political party in Canada, who's always been historically hesitant to adopt carbon pricing, finally came out with a carbon pricing plan, a climate change plan that includes carbon pricing. And that's a big step. Looking forward, it was always a question of if the Conservatives won the election and not the Liberals, for example, what would the carbon price be? And in the past, we would have to consider it, would it be 170 in 2030 or actually zero, because they had no carbon pricing. Today, they've stated their plan. It's more in the $50 range, but I think it's a clear signal that carbon pricing is here to stay in Canada, and that helps decisions being made by those that are emitting going forward. So again, a lot of the the frameworks that we will have in Canada will depend on the political parties in charge, but carbon pricing's here. And going back to the cap and trade discussion, we have had the Ontario NDP, the state that if they win the next provincial election, they would actually bring back cap and trade. So, it's a bit messy. A lot of different paths that can be taken both at the federal and provincial level. Hopefully over the next few years, we'll get some certainty and some programs that remain stable and remain stable like the Quebec program, as a matter of fact. They're probably the most stable program we have in Canada. So we'll be very interested to see what happens with that program, including will the federal government, if the current federal government is in charge over the next little while, will they continue to accept the carbon price that we see in Quebec? Or will they potentially threaten the linkage with California by having them have to change their carbon price in Quebec? The last point I just wanted to mention, just to show, and I think I'll leave the rest of this for Chelsea, is, as I mentioned, the offset system, the protocols that were being developed and the system itself by the federal government for the federal program, which currently would include Ontario, Saskatchewan, and a few other provinces, is just not there. And there's a demand. The market is short when it comes to the OBPS and those provinces in it. The compliance was just made for the first time last week for the 2019 emissions. The issue was there was 0 offsets made available for that program, which meant that everyone essentially paid the carbon price directly to the federal government. The next payment is actually December this year. There was a delay from the previous one because of COVID. So we have another payment coming up for 2020 emissions this December. We will see the same result, essentially 0 offsets being utilized by emitters, even though for those first 2 years, they could utilize 100% offsets if they had them available to them. So hopefully this will change quickly for offset developers and for emitters for lower cost compliance units. But following the progress of the offset development, and more importantly, what will be the role of a federal system going forward? Will there be a OBPS, a federal system that requires offsets, or will the provinces all have their own programs? And therefore, what will be the use of the federal offset program, which I believe Chelsea will get into. So I think I'll leave it at that, and we'll pass on to Chelsea.
Thanks, Mike. That was a great presentation. It's always good to see the visuals of what this actually looks like. So I think there's a few points that I just want to add that Michael and Jonathan have touched upon today. So first and foremost, the program design component is so mission critical. And so what I mean by that is there's a conversation about carbon price, and Michael obviously mentioned, where there'll be pressure for Quebec to increase its carbon price to match that federal minimum price. Price is one aspect of it, but really how the inherent benchmarks are set for each of these programs. So what aspect of your emissions are actually priced is incredibly important when you're looking at industry level competitiveness under these programs. And so you could have a system that has a lower carbon price, but a larger component of those emissions are covered under that system. So your benchmark is lower, therefore you're paying on a larger amount of your emissions and actually have a larger cost than at a higher price level. So what we have seen across Canada with the federal minimum price is now we're going to have consistency outside of cap and trade program design systems around a minimum carbon price. And with the great details that Jonathan gave about the Supreme Court decision, that is going to be upheld. And so in a system like Alberta, which is the longest standing carbon market in North America, which has actually been very resilient. We've seen several government changes and the program has continued in effect. So unlike what we saw happen in Ontario, where with a government change, we're seeing this snap response where the systems can be canceled and replaced with another system, Alberta, irrespective of those government changes, has had consistency to that market. And so in a system like Alberta, the government would not maintain compliance if it didn't increase the price to meet that minimum federal pricing standard that's set into place. So we saw that happen in November of last year, where they increased the price to $40 a ton as of Jan 1st to match the federal minimum. And we would expect to see that later this year, that again, that price would increase to $50 a ton to meet that federal minimum. Then the question goes, okay, now that we see this pricing out till 2030 at $170 price point, what does that mean? What does that look like in terms of federal government potential changes over time? And where do we actually get to in terms of carbon pricing in Canada? With the Alberta system, I want to just touch on quickly, there is a concept of recognized units, and that means that there's Alberta offsets that are fungible into the federal system. So as Michael had mentioned, there's currently no offsets under the federal system, although ECCC is working at bringing protocols into approval so that the federal system can have its own offsets that are created to meet that demand that Michael had mentioned. But currently, those protocols aren't approved. And so the only compliance instruments that can be used under the federal OBPS is actually a subset of the Alberta offset market. So there's a selection of protocols that have been approved by the federal government, and those credits can actually be transitioned into the OBPS system to be used against that compliance demand. I think another really important aspect to mention is what we're seeing happen in voluntary markets. So when we think about compliance versus voluntary markets, compliance is obviously a government mandated system that requires a certain component of industrial emitters to meet emission reduction targets and have associated compliance obligations under those systems. When you talk about voluntary markets, you're talking about the significant amount of voluntary commitments we're seeing from corporates, associations, even individuals around emission reduction targets and carbon neutrality. And so the action that's happened in the voluntary market in Q1 of this year has been unprecedented to what we've seen historically. And what you can start to see happen is, depending on that price point and the associated demand of the voluntary market, you can see voluntary markets poach compliance supply. We saw that happen historically in Alberta many years ago when the ceiling price was at $15 a ton. There was instances where renewable energy compliance grade credits would be potentially transitioned into the voluntary market there. We're starting to see that potentially happen in California, where the compliance carbon offsets are not necessarily at a peak price, and the voluntary demand specific to certain jurisdictions is going up quite substantively. And so when you see these types of markets interact, suddenly you can have a situation where voluntary markets poach that compliance supply, and that can actually have implications on market fundamentals. So although I don't suspect in the very short term that we're going to see the voluntary market poach credits that are approaching a $40 ceiling and potentially, exceeding by the end of this year, that dynamic can quickly change with the level of commitments that we're seeing on a voluntary basis. So I think it really is an important dynamic to at least consider as we're looking at these systems, because certainly we're starting to see it happen in other cap and trade systems that have lower price points. With that, I think I'll turn it back to Matt, because I know that there's a substantive amount of interesting questions that he has to put towards the panel.
There certainly are. And thanks, Chelsea, and thanks, Mike and Jonathan, for your presentations as well. So I guess maybe one of the first questions that I have actually came out of something that both Mike and Chelsea said, and that relates to supply and demand for offsets under both the federal system and under the Alberta system. Because Mike, if I read your slide correctly that you had on federal backstop output-based pricing system supply and demand, did that take into account Ontario starting its own EPS from 2022? Because it looked like there was a really big discrepancy between the short position that would be from this year and then the short position that would be next year from the largest emitting backstop province going into its own system, correct?
Yeah, so if I'll pull it up here. So there's a few changes that occur in 2023 of that chart. And one is the offset usage drops from 100% to 75%. But we've also removed Ontario from that demand, because they also, the schedule is they'll have their EPS plan starting in 2022. So 2022 is when we had that drop. But there's been some recent changes just the other day, and we probably have to update that, which was very interesting, is that Ontario was recently approved to have their provincial program start in 2022. Whereas New Brunswick would just announced to have their provincial program approved retroactively for 2021. So that will change the dynamics slightly, even though New Brunswick wasn't a major demand side as a province. But that's very unique, and I think it's going to be very interesting to see, why was one given a retroactive versus the other one given it to 2022. And I think just to take a chance to talk about this in equivalency, the reality is they were deemed back in the fall to be equivalent, these two programs. And I know, Chelsea, you mentioned, Alberta will have to go through every year as being deemed equivalent. The reality is those two provinces were deemed equivalent the day before the Supreme Court case. And in our opinion, that had nothing to do with any parameters re-equivalency. It had to do with politics. And that's very unfortunate. And that leads to more of this uncertainty because, what are the criteria used to deem provincial programs to be equivalent or not? So that's still going to be interesting to see, especially going forward. Maybe they'll be more clear in that now that the court case has given them some strength. Will be very important to see what do they use as the tools to deem equivalency going forward, especially on all provinces, including Alberta, including Quebec. And just one last point, you would actually think that the demand would go even lower, but a lot of the demand actually comes from Saskatchewan on the electricity side and natural gas side, which are still in OBPS, which have a significant amount of emissions in proportion to the size of the province. But again, going forward, will Saskatchewan not have their own full plan? And they've said they're going to look to do that. So that may happen as well. And that whole supply and demand completely changes.
One of the things I wanted to add that's particularly interesting to think about is each of these systems and the associated compliance instruments. So conceptually speaking, under the federal system, you do have recognized units that you can use under the system now. So you do have some form of compliance instrument that can be used, and arguably they're developing a federal offset system, so you're going to have additional compliance instruments. Ontario hasn't contemplated the use of offsets under the regulation, but what becomes really, really interesting is you're looking at these minimum price thresholds that are ratcheting up by, the next step change is $10, but then it goes up by $15 a year up to $170. Really, really substantive cost levels for these organizations and these industrials. So you can imagine one organization who's under a system like Alberta or a federal OBPS has the ability to go in, buy credits, and hedge them against future compliance obligations. So now you can look at what you anticipate your compliance obligation to be over a 5-year period, purchase credits in the market today, and use them against those compliance costs at current market pricing. You have another organization that doesn't have compliance instruments, and suddenly they're facing a $15 per ton increase each year because effectively without a compliance instrument, the program functions like a carbon tax. So you can really very quickly have some serious competitiveness issues for domestic industry when you have a facility in a jurisdiction that you have no ability to hedge versus a facility in a jurisdiction where you can hedge against those future increases. So really interesting dynamics to consider, and certainly I think are going to be part of the narrative as some of these provincial programs look at their designs going forward.
I guess just a follow-up on that, Chelsea, and this I think will tie in a listener question as well. You mentioned the ability for backstop emitters under the federal program to use recognized units from approved Alberta protocols for compliance. The first compliance period for backstop OBPS came and went, as Mike mentioned. However, the 2019 backstop price for OBPS was $20 per ton, whereas the price under the Alberta system, that's the Technology Innovation and Emissions Reduction Regime, was $30 that year, correct? And now it's 40. And so speaking with folks in the market, no one thought that any Alberta offsets would actually flow into the federal system for use by, let's say, Ontario or Saskatchewan and New Brunswick emitters this year. But what do you foresee, I guess, maybe either this year or next year while Ontario is still in the program? Because currently you have Alberta offsets that are really kind of around record highs, have been for most of the year, right? Depending on delivery date, you can go from the mid-high $30 Canadian dollars up until maybe 45 for further delivery dates. But what's your outlook there based on the current Alberta supply and demand dynamics? And to time this listener question, can you just name the protocols that have been recognized by the feds from Alberta? I think I have those handy if you don't.
Yeah, so I'll be completely candid. The only protocol that has any real volume that could do recognized units is the pneumatics protocol. So you can absolutely, Matt, I'll defer to you to read the other protocols off the list, but the level of volume is just not there. So really what you're talking about is the pneumatics protocol and those credits being transitioned. So to answer your question, absolutely not. When you have a $20 ceiling in one system, a $30 ceiling in the other, there's no functional way that an organization is going to trade into a lower price system. Otherwise, those people probably shouldn't have jobs. But when you're starting to match the system, really what I would expect to see is that an OBPS emitter would have to pay a premium to what the Alberta market price is just to deal with the administrative friction of transitioning a credit into another system, because obviously it's very easy to sell to an Alberta emitter from an Alberta system. There's extra steps that need to be taken to sell it into the OBPS, but accounting for that administrative friction, as long as the associated supply has a return, then they will absolutely sell into that system. I shouldn't say that. Organizations that would sell into that system. Maybe not all. So I think that's an important element, that there is extra steps that need to be taken. Certainly with us, we've had conversations with ECCC as Radicle to understand what that process is around the transition of credits into the federal OBPS. But that is something that would need to be considered. It's the easy button to sell into the Alberta system, but organizations do have access to a market that they could use to hedge out their forward compliance obligations under the OBPS currently.
Yeah, and thanks. Just to add to that, I think, with your pricing that you mentioned, December, the December compliance that we have under OBPS will be at a reference price of $30. So you're already outpriced for Alberta for the next period. Now we're talking 2021 when the reference price in OBPS was 40. What will Alberta offsets be doing around the time that, how early do you actually want to go out and buy Alberta offsets in Ontario and other OBPS jurisdictions? So, what will the price be when you get closer to the $40 compliance deadline of December 2022 for 2021? And our expectation is, those Alberta offsets will probably not be used in LBPS for those timing issues, but we'll see. And then the question is, what's left in OBPS after this? So just to touch on again, the federal program, as Chelsea said, can be an excellent opportunity for voluntary markets. It's going to be a great stamp of approval to have a Canadian government approving offsets. The next question is, will other provinces use this program as a fungible unit for their program? And most importantly, will Ontario? Ontario's first draft of the EPS did include offsets. They rushed that draft. It's 5 pages long. It's not much. It was really used for political purposes to present at the different court cases. The question now is, will they reinsert offsets back into their program? Because it's only, there's not much there, and emitters want to use them. So the question is, will they do it, and will they use the federal system? It seems like a logical choice.
And to tie back into Michael's comment, organizations are currently hedging against their 2021 and 2022 compliance obligations because of where the pricing of the market is trading at. So certainly in Alberta, we have a compliance deadline that's coming up in a month and a half. There really is no supply because the price has obviously exceeded the current ceiling price. So really it's about a long-term hedge strategy against this significant escalation in price that organizations are looking at this and saying, you know what, we're going to look at a multi-year hedge because ultimately, otherwise we're just going to be paying at that increased price every year because the market will be trading above that price level.
Yeah, and exactly that. The issue being in Ontario, no emitter wanted to do a forward hedge. Just a few weeks ago, we were announced that EPS will start in 2022. We were just told New Brunswick gets 2021. Well, it's not absurd if Ontario potentially goes back and says, why don't we have 2021? And if that's the case, what are you going to do with an Alberta offset if you bought it for 2021 use or 2022 use? And it's just, that's that lack of stability in Ontario makes emitters very hesitant to hold on to any credits for any length of time, especially what we saw in cap and trade, where there was a long process to get compensated for those emitters that did buy allowances. So the history of all this political uncertainty leads to the non-ideal situation where, as Chelsea says, it makes perfect sense to be hedging properly, but there's a fear to do that in Ontario, unfortunately.
So yeah, organizations in that situation would then need to sell it back to an Alberta compliance entity to use it against their obligations. So whether they would want to do that or not is questionable, to your point, Michael.
So to pin you both down, potentially, like yes or no question, do you think, based on everything you've just said relating to pricing levels, hedging strategy, political uncertainty, do you think that backstop OBPS emitters will use Alberta offsets for 2020 compliance? Yes or no?
No,
No,
because the price is already above the 2020 ceiling. So there's nothing for them to access. I can tell you right now that Alberta compliance entities are looking for credits to use for 2020 compliance, and there isn't anything.
Yeah. I think the question is more the 2021.
2021, yeah.
And I think that the hedging hesitation will probably mean they don't, my guess. Yeah.
If any compliance entities across Canada, so, we're obviously talking about Ontario, but there's also systems that are still under the program, even post 2021. If they're wanting to hedge out their compliance obligation, they're hedging out their compliance obligation now for 2021. And maybe a little bit like a year out from now, they could look at 2022. But if you even wait within this year, that price could exceed the 2021 ceiling potentially. So there's a lot of moving pieces that it has to be a consideration of a forward hedge. Otherwise, you still pay at that's ever increasing ceiling price.
Excellent. Well, I think we could talk about offset hedging strategies all day, but I do want to move on to other topics, and I think some that could get Jonathan involved in here too. But staying within this whole federal provincial dynamic, in February, ECCC, or Environment and Climate Change Canada, the federal environment ministry, kicked off their consultation process for not reforming, but for making changes potentially to the backstop output-based pricing system after 2022, so after next year. And one of the things that was mentioned in this consultation was taking a look at potentially tightening the output-based standards that constitute this program and the benchmarks that regulated emitters in the industrial and electricity sectors have to meet in order to maintain their compliance obligations. If not, they have to go out to the market and buy offsets we're talking about, or buy surplus credits from entities that beat their benchmarks, or they pay the excess emissions charge, the backstop carbon price. I guess with the current landscape of the provincial programs, and especially those that are going to go from federal to provincial, like New Brunswick and Ontario and potentially Saskatchewan, I guess what are the implications then for a federal backstop that might mandate or set out tightening output-based standards? And especially my question for Jonathan too on this is, in light of the Supreme Court decision and the language that was handed down by the courts as far as what the federal government has the ability to do through its Greenhouse Gas Pollution Pricing Act in Schedule 1 and Schedule 2 of this, or I guess Schedule 2 in this case, what kind of mandate would the federal government have in light of this court case in order to pursue this, should it want to? Anyone can go first here.
Well, I think it'll be very interesting to see how this moves ahead. I mean, the court case made it very clear that the main effect of the federal law is to set minimum national standards for GHG price stringency, and there is a significant degree of discretion afforded to the federal cabinet to decide which provinces meet those minimum standards for price stringency and which provinces don't. That's in the law as it stands right now, and that's in the law as it was upheld by the Supreme Court. On another side of the legal equation, there is currently an ongoing judicial review before the Federal Court of Canada that was launched by the province of Manitoba that also goes to the constitutionality of the Greenhouse Gas Pollution Pricing Act, but not from the point of view of its constitutional validity, but rather its constitutional applicability to different entities. And that's ongoing. It's not resolved yet. I think the Supreme Court decision will have a significant impact on how it gets resolved, but there may be some uncertainty around whether or not the federal law can apply to all entities in all provinces. There may also be some issue around the discretion afforded to the federal cabinet in the current law about where the federal scheme applies. And it was notable that the letters from the Minister of the Environment at the federal level that came out in reference to Ontario and New Brunswick and standing down the OBPS in those two jurisdictions that came out the day before the Supreme Court hearing back in September. So there are some political elements to this that are also at play.
Also, Mike, any of you want to take a stab?
Maybe our biggest concern, and I say that in regards to market and stability and rewarding early movers, is what will this equivalency look like for Quebec and for Quebec cap and trade? We believe that it's a strong market. We see emitters making key decisions because they understand the market. They have price understanding, at least comfort. They can hedge. They can make those decisions. And they have a partner in California, they've had a partner with for a long time. If somehow the federal government starts to apply equivalency that somehow deems the Quebec program not equivalent, and they have to change their price, for example, the first question is, what would that do to linkage with Quebec? To California, sorry. How will that change the the price. Can they change the price? I don't think so. I don't think they can have a proper market if between Quebec and California if there's two different prices. So there's a threatening of the linkage with California, which I've said in the last talk. I think that'd be a big shame, especially I think the day before we had the last talk, the U.S. came out saying they're going to pull the Trump court case to sort of threaten the linkage with California and Quebec. I find it very disappointing potentially if it's the federal government of Canada that will be the one threatening the linkage between California and Quebec potentially. So I hope they take that into consideration when looking at all these different parameters of what they want to deem equivalent or not.
Yeah, and I guess the only comment that I would add to this is domestic competitiveness is incredibly important when you look at each individual system. So if you have one system that has a very substantively different benchmark, so let's say that the benchmark level is much higher emissions intensity than another system, and you have facilities in each of those jurisdictions that are competing with each other, as you have an escalating carbon price at the levels we're seeing, you're going to hear a lot more about competitiveness of industry and equivalency of system design as a conversation point, I think. It ties into the conversation about compliance instruments and how if you don't have them under certain systems, it's gonna be very penalizing to those systems. The same thing can be said about benchmarks. If you have very different benchmarking, I suspect that those conversations are going to be elevated within each of their respective provincial governments and maybe even will be discussed federally. And then I'm very curious to understand how the federal government looks at that when they're looking at the actual benchmark design and the levels of emissions that are covered under each of these systems from an equivalency basis going forward.
Mm-hmm.
I did want to add to for the person that had the question regarding the Alberta protocols for the federal system. I did post that in the chat just in case you haven't seen. But you mentioned, Mike, the U.S.-Canada interplay, and of course last week was the Leaders Climate Summit in which both countries made enhanced commitments to the Paris Agreement. For the U.S., that's 50 to 52% greenhouse gas reductions below 2005 levels by 2030. For Canada, it is 40 to 45%. As the person that finally resides in a country with a higher greenhouse gas reduction target than Canada, I can ask you all these questions. So I guess, what does this new enhanced NDC though for Canada, and even in relation to the US on climate policy, I guess, what does this mean for Canada's plans to, I guess, hike the backstop price to 170? Does this really lead the federal government to dig in its heels more in negotiations with the provinces and the territories regarding future increases? I guess, how does this relate to maybe like harmonization between, the various electricity markets of the country? Canada has a relatively clean grid and extremely clean in places like Quebec, for example, whereas the U.S. is, far more fossil intensive. I guess, what are your thoughts on that and how it might affect the current landscape of carbon pricing across the country?
Who wants to go?
Mike, you want to go first, or shall I?
I can go ahead, Jonathan. You jump in first.
Well, I can weigh in on the final point to some extent, Matt. I mean, I think we are seeing a harmonization of electricity and carbon markets to a significant extent, and that really does play into Canada-U.S. relations. Like, in light of the new NDCs announced last week, right in the U.S. NDC is the goal of the goal of 100% GHG-free electricity by 2035. In Canada, we have a goal of 90% of Canada's electricity coming from non-emitting sources by 2030. And there's huge potential and opportunity for integration of the electricity systems between our two jurisdictions. There are 37 major transmission interties between Canada and the US that provide numerous benefits for electricity, reliability, affordability, resilience, economic benefits, but also those potential climate benefits. As you mentioned, Quebec has very clean electricity, as does Ontario and Manitoba and BC, and also ties into recent announcement from Prime Minister Trudeau and President Biden on a coordinated approach to cross-border electricity transmission. So lots of opportunity there, and I think will also tie into other elements of Canada-US cooperation on the climate file.
The one comment that I wanted to make is I think if you look at it kind of at the highest level, when you have an increase in stringency of NDCs, then from a top-down approach from the federal government looks at different policy mechanisms that they can use to drive down emissions, it starts to add incremental opportunities or thought process about system designs that they're going to be probably contemplating. So I think it's more if you're kind of coming at it from a top-down perspective, they're going to start to look at what is it that we need to do to hit these NDC targets holistically, and then it gets into what I would call the more granular discussions where you have the, provincial and national, federal level negotiations around the system design. So again, if lower amounts of your emissions are covered with carbon pricing, then you're obviously not going to have as strong a single signal for those reductions. So does that all of a sudden play into the conversation about system equivalency? Because in absence of system equivalency, you may see a lower level of emission reduction. Alberta is a perfect example of this, where you had a best in class gas standard on the electricity generation in the province. So although you had flexibility to convert off of coal out till 2030, we're obviously seeing those happen a lot sooner, and that's simply because the carbon price is incentivizing those types of business investments and decisions to be made. So the concern I always have is when you have it at the top sort of federal level, looking down at what all the different policy decisions that can be made in order to drive emission reduction targets. Does that all of a sudden create overlapping mechanisms? What is the interaction between these different systems? So there's obviously the conversation about the clean fuel system and the overarching federal and provincial carbon pricing systems. How does that interact? How do all those pieces play into individual organizational level competitiveness? So if you have multiple systems that are increasing input costs, what does that do to domestic competitiveness? How does that compare to having a facility built just over the border in the US? So it's not a benefit to Canada if we have investments going into another jurisdiction and they're still emitting in that other jurisdiction, because this is a global problem. So we need to see, programs that incentivize the right signals to see domestic investment, but also to see more efficient facilities and production going forward.
And just add that's perfect, Chelsea. I think for me, I was just going to mention, I think the announcements from the U.S. side actually, I think are even more important, because the typical question we have when we're sitting down with an emitter is, why should I be facing carbon pricing? I just go across the border with my own facility and produce there, or make investments there because they're not facing any carbon costs or carbon pricing. So I think, how will the U.S. meet their targets? I assume there's going to be something that's going to be put in place, and that will maybe reduce some of that uncertainty and questions on this side, saying, okay, you know what? No matter where I have my production, at least in North America, they're going to face some sort of cost. So I don't want to think about leaving Ontario, for example, or Alberta so quickly.
Absolutely. Carbon leakage is not to the benefit of anyone. We want to see more efficiency going forward.
A question that I just saw come up in the chat on carbon adjustments. I think President Biden and Secretary Kerry, and it was both in Canada's fall economic statement and again in the federal budget last week. It's an ongoing conversation, very likely to be advanced over the next little while. I think the Canadian government plans to start a consultation very soon and broaden that out. And there's likely to be significant developments in terms of a potential border carbon adjustment, North America-wide or Canada and the US hopefully cooperating on that.
Yeah, it should be interesting. I think I mentioned the last talk that I saw someone mention, well, the U.S. should talk about carbon border adjustments when they have a carbon price. And the response I have,
Right.
What is the Canadian carbon price, along our border? We saw the map, it's all over the place. So how will that be worked out? We can leave that to the smart people, but it doesn't seem like even for Canada, we have a very clear price, unlike the EU, for example.
There's a couple of viewer questions in here for Chelsea that I would like to get in. One of them Alberta specific, one of them voluntary. So the Alberta question is, with the termination of the province's conservation cropping protocol that will sunset at the end of this year, I believe. What is the future for agriculture soil carbon offsets in Alberta with the lack of additionality? Would that potentially transition to the voluntary market or be used for backstop emitters in the OBPS? And then the second question is, what are the market fundamental impacts due to voluntary players poaching compliance eligible credits? Perhaps it's more of a California question, since I don't know if that's really happening in Alberta at current price levels, as you were mentioning, but just wondering if you have any thoughts there.
Yeah, so on the ag side, that's $1 million question. I know that there's a lot of very, very smart people hard at work and there's incremental protocols in place at a voluntary level. Also, the federal government, in designing their OBPS system, one of the initial protocols that they're designing is a soil sequestration protocol. So when you think about agricultural emission reductions, you can't just think about it solely as, conservation cropping. That's one aspect of emission reductions, but certainly there's other things that can be done. And so I think that there's still a lack of clarity on exactly what that's going to look like, because ultimately when you're looking at a protocol design, one of the most important things is whether the activity itself is economically viable. So you need to ensure the rigor around the emission reduction, that it meets all the quality standards. So that's certainly, top, front, and center. But assuming that that is the case, the second piece is you can have a great protocol that meets all that, but if it's not economically viable to actually do the activity, you're never going to see a single credit. So it's certainly not beholden on anyone having protocols that are designed that way. So it's really important to look at both aspects. What's the practical use of the protocol and how it's designed, and obviously that it meets very high levels of rigor around the environmental integrity of the emission reduction. So unfortunately, I don't have any answers for you other than to say that, again, there's a lot of very smart people hard at work that are looking at the agricultural sector, my organization included, in terms of what the future opportunities are in that sector. And then the second piece, Matt, quickly refresh me. What was the second question?
Yeah, market fundamentals of voluntary players poaching compliance eligible credits.
Yeah, so I mean, in Canada, it's not an issue right now, but it's something that you really need to consider, because you wouldn't have seen that historically in California either. So you haven't seen like the market fundamentals flip in California, where all of a sudden all the credits are going into the voluntary market. Certainly, it's very specific to the project type, jurisdiction, location. But as that price continues to go up with a very substantive level of commitments out to 2030, you can't assume that you won't see some of this happen. And specific to what I would call your very charismatic project types, where they have a lot of really amazing co-benefits and other environmental attributes that are associated with them that would be attractive to the voluntary market. So certainly there is preference for specific protocols. Nature-based solutions have a very strong desirable traits in the voluntary market specifically. So when you're looking at specific protocols, certainly you can see where in the future you could have those credits trading into a voluntary market with a higher price signal than a compliance market potentially. It's just something to consider. But we're still quite a bit off when we're looking at a $40 and $50 ceiling in Canada, going up to 65. You may never catch it with the voluntary market. It'll be interesting to see how that dynamic plays out.
And thanks, Joseph. And just to add to that, Matt, I think almost from the other side, we're seeing developers saying, okay, I have a project. I'm not exactly sure yet, because the offset protocols have been so slow to be developed federally. Will this project be eligible? Will it actually have demand under OBPS? And the question then is, well, what's my bottom? And right now the bottom is the voluntary market, most likely. A Canadian offset project that's deemed to be a decent offset project will have decent value in the voluntary market. So I think it will spur more, the voluntary market demand will spur more offsets projects being developed, and potentially for the OBPS markets or other provincial markets, but at least it has sort of that floor with the voluntary market. So we'll see hopefully more offset projects, high quality offset projects being developed.
Kudos to my panelists here that ended at 11 o'clock on the dot Central Time. And we know that the keynote speaker, Wisconsin Lieutenant Governor, is kicking off now. So want everyone to get over to that. But thanks again to Chelsea, Mike, and Jonathan for really bringing in some kind of tremendous info and discussion into this panel. Unfortunately, I didn't get to ask you all what you think the Nova Scotia auction will clear out in June, but we might be able to do our own hour-long webinar to discuss supply and demand fundamentals in that market. But until then, thanks everyone for tuning in. Stay safe, get your vaccine when you get the opportunity, and I look forward to hopefully doing this in person next year.
Okay.
Thanks so much, Matt.
Thanks everyone. Thanks, Matt.
Everyone. Bye.
Bye.